Advocacy chooses to stand by one side for justice's sake. Mediation chooses to stand in connection to all sides for justice's sake. In the previous segment, we addressed the potential obstacles that self-represented litigants may confront and may prevent them from meaningfully participating in mediation. And these included lack of understanding of the law and their legal rights, lack of experience and knowledge about the court system and the litigation process, lack of knowledge about the range of possible outcomes and their likelihood if the case is adjudicated, lack of experience and knowledge about the mediation process, and finally, lack of experience and knowledge about negotiation best practices. In this section, we address the tension between a mediator's responsibility to ensure that, despite these obstacles, self-represented litigants participate meaningfully in the mediation process, and their mediator's responsibility to maintain a fair process for all participants, represented or not. Here are our learning objectives specifically. First, understand your duty of promoting self-determination. Second, understand your duty of impartiality. And then finally, understand your duty to conduct a quality process. It is also important to appreciate that tensions may exist among these duties when mediating with self-represented litigants. The rest of this course is designed to give you practical guidance using simulated mediations about how to balance the competing ethical obligations discussed in this section. Promoting party self-determination. The California rules state, in part, a mediator must conduct the mediation in a manner that supports the principles of voluntary participation and self-determination by the parties. In so many ways, voluntary participation and self-determination is really what mediation is about, and it always must be kept in mind as we move forward with the process, especially with self-represented litigants who can often be so swayed by us as professionals and by mediators. So the minimum standard for self-determination, this is what it means. The parties voluntarily agree to any resolution. The parties decide their level of participation in the process, including the right to withdraw at any time. And the mediator must not coerce any party to make a decision or continue to participate in a mediation. Impartiality. The California Rules of Court provide that a mediator must maintain impartiality toward all participants in the mediation process at all times. And impartiality means you must act free from bias and exhibit even-handedness in the treatment of all participants. This may be difficult because due to the many obstacles they face, self-represented litigants may need more support to meaningfully participate in mediation than a lawyer or a savvy business person. And this brings us to another California rule of court that mediators must bear in mind when dealing with self-represented litigants. A mediator must inform all participants at or before the onset of the first mediation session that during the mediation he or she will not represent any participant as a lawyer or perform professional services in any capacity other than as an impartial mediator. Quality process, procedural fairness. The California Rules of Court state the following. A mediator must conduct the mediation proceedings in a procedurally fair manner. Procedural fairness means a balanced process in which each party is given an opportunity to participate and make uncoerced decisions. But you need to be aware that because of your role as mediator, you may have more influence on the self-represented litigant than you realize. And even though you may not intend this, the self-represented litigant may feel as if she's being coerced into agreeing to something that she really doesn't want. Quality process, substantive fairness. The California Rules of Court also state a mediator is not obligated to ensure the substantive fairness of an agreement reached by the parties. Of course, mediators will try to have a balanced process and engage in procedures that help the parties come to the best solution for them. Remember, you are not a guarantor of the fairness of the outcome of the mediation process. There are tensions among these different ethical obligations. Reviewing these obligations, party self-determination, impartiality, quality process, you can see these tensions and how you might encounter them in a mediation involving self-represented litigants. Under California law, as a mediator, you have an obligation to conduct procedurally fair mediation processes, one in which all parties are given an opportunity to participate and make uncoerced decisions. As we have seen in the obstacle section, self-represented litigants often function under significant disadvantages that make it difficult to participate effectively in the mediation process. So, moving forward, we must help self-represented litigants to meaningfully participate in mediation, balancing our ethical obligations, in particular, impartiality. To what extent can you explain the rules of evidence, for example, to a self-represented litigant and still maintain your impartiality, even if the explanation would help the self-represented litigant to some extent? To what extent can you explain the law? To what extent can you help the self-represented litigant to see the strengths and the weaknesses of their case? In the following segments, we're going to answer these questions, and we're going to discuss and demonstrate techniques to help mediators make the self-represented litigant experience as meaningful as possible. But this has to be within the rules of conduct for mediators in court-connected mediation programs for civil cases in California.